Welcome to the Semi-Interesting Podcast, where we explore some of the unique legal issues in the global semiconductor industry. My name is Nathaniel Lucek. I'm an IP attorney at the law firm of Hodgson Russ, and one of your hosts.
My name is Elizabeth Morris. I'm an IP attorney and the Director of Intellectual Property and Products at Pure Storage in Santa Clara, California, and I am one of your hosts.
Artificial intelligence and semiconductors are linked. Obviously, semiconductors are the underlying technology that runs AI, and companies sell a lot of high-end chips, which benefits the whole industry, from chip manufacturers to equipment manufacturers to vendors and other companies in the supply chain. There are still negative impacts to the industry, though, including with IP. We wanted to explore some of these bad sides and other impacts a little bit more from an IP standpoint. And sure, we know that sending trade secrets outside the safe confines of your company can jeopardize IP protection, but what about some of the other impacts to trade secrets that are coming as the use of artificial intelligence grows both inside and outside your company? We're joined on this episode by Steve Balcof to discuss AI's impact on how we may need to evaluate and protect trade secrets in the future. Steve, thanks for joining us. Before we get to some of the detailed questions on trade secrets, why don't you give everyone a quick introduction yourself?
Thanks, Nathaniel, and thanks to you and Elizabeth for having me today. Like Nathaniel said, my name is Steve Balcof. I am an IP litigator and a partner at Demaris LLP. We are a tech-related litigation shop with offices in New York, DC, and San Francisco. And we handle high-tech and life sciences cases in district court at the ITC and at the PTAB. Personally, I've been in IP litigation for almost 15 years. My docket is 50% patent work and 50% trade secret work. And within those two buckets, I litigate and try district court cases, and I counsel clients through pre-litigation diligence, avoidance, and preparation projects. So trade secrets play a pretty large part in my life day to day.
We're so happy to have you on, Steve. I know I spend a lot of time mostly thinking about patents and patent litigation, but we were specifically interested today in hearing about trade secret and how it relates to AI and concerns there. But before we dive into, the details there, can you give us a quick overview of, what makes an information a trade secret so we kind of have a level set here?
Sure, that's a good idea. There's three things that define a trade secret, at least from a legal perspective. The first one is it's not publicly known, also known as it's actually secret. The second is whether the information has independent economic value from not being generally known to the public. And a really easy way to think about that is, does this information offer you a competitive advantage? And we can talk about that a little bit more as we get into the details. And then the last piece is, did you, as a company, take reasonable measures to keep that information secret?
Thanks for that. Why don't we start with how AI can be used at this point to kick us off? So one of the things many people do is, if you need help, is just plug something into ChatGPT or choose a different AI module in order to get an answer. And that could be write me an email to something a little bit more complex, like what is the Coca-Cola formula? And it is able to spit out an answer. Now, whether or not that answer is correct or can be easily verified, let's ignore that for a moment. But if AI can approximate what you're doing and spit out something that looks like your trade secret, how does that affect the generally known prong of the test for trade secrets?
That's a really good question. And the answer is complicated, but I think we can break it down. Generally, when you're looking at a trade secret and you're going to litigate it against another party, the party needs to show that the entirety of the trade secret is publicly known. So Coca-Cola formula is a great example. It's a very popular one in terms of talking about trade secrets. And I've actually plugged that very question into ChatGPT just to see what happens. And it gives you a pretty detailed answer. It's really interesting, but it also has a little bit of a fudge factor. And it says, oh, and there's also a bunch of other flavors that we don't know. And the reason for that is the Coca-Cola formula is still a trade secret. So from a technical perspective, unless the information is all there, your information is still a trade secret. Now, I think where this gets interesting is how the availability of trade secret approximations through AI impact this next prong, the value of the trade secret.
So I'm just over here, typing that question into ChatGPT to get an answer. It seems like, if you can get pretty close, right? AI can approximate what you're doing. I mean, maybe legally, and we are all lawyers here on this chat, but maybe legally it's still trade secret. But what is the value of a trade secret if, this recipe that I'm looking at could get me something that at least my palate might not be able to distinguish?
There's two prongs to the answer. The first is taking a look at the type of value a company attributes to a particular trade secret. And the second is what type of information are we talking about? So, as to the value, like I said earlier, it's helpful to think about the value prong as competitive advantage. What does this information give your company that is an advantage over your competitors? Whether it's allows you to be the first market mover, it's an exclusive feature that only your company can offer, the resources, the time that have been invested in developing a certain product or feature, or it's just a desirable product differentiator that your trade secret allows your company to offer and no one else's. And so all of those things, those types of value can come into play for any given piece of information. And I think AI can have a different impact depending on how your company looks at it, right? So from a time cost of development perspective, if that's the value inherent in a particular trade secret, and now AI can get you 95% of the way there, well, yeah, you know what? That trade secret isn't as valuable as it used to be before AI got good at what it does. First market mover. If you're still going to be able to get on the market first, and now AI can kind of figure out what you did after the fact, that's not going to have as much of an impact on the value. Exclusivity, desirable product differentiator, that's really going to come down to, and this is going to segue into the next prong, the type of information we're talking about. Coca-Cola and its formula is a really interesting model because it's not even just about the information itself. It's also a marketing ploy. Coca-Cola, everyone knows, or a lot of people know, that they have the formula, it's a trade secret, and it's in a vault at the Coca-Cola Museum in Atlanta. That's marketing. That's brilliant, brilliant marketing. And so even if 98% of the Coca-Cola formula is known out there, it's still not the real thing. It's still not Coca-Cola. You can't say that this drink that I made using my AI approximated formula is Coca-Cola. And so there's still a ton of value there. And we're using the Coca-Cola as an illustration, but there are situations like you kind of implied where maybe that last 2% doesn't really matter. Let's say Nathaniel, he's known for his chocolate chip cookies, right? And he decides that he's going to keep his recipe a trade secret. Now, I'm not a baker, but the chocolate chip cookie is pretty ubiquitous. And the ways to make it are, I think, a known set. So if I go online and I say, give me a chocolate chip cookie recipe, and it gives me 10 of them, and number 7 is pretty close to Nathaniel's, then I don't know how valuable Nathaniel's chocolate chip cookie recipe is, because it's all going to taste very similar to each other. Nathaniel isn't on the same level as Coca-Cola. And so the value depreciation factor due to AI is significant. And so it really just depends on the value of the information and the type of information that we're talking about.
Let's flip this around a little bit. So what happens in my example if I generated my cookie recipe using AI? So I want to keep that as a trade secret. I mean, what's the value behind my new chocolate chip cookie recipe derived from what AI presented to me as the optimal formula?
Yeah. So I think this is kind of where AI gets a little bit of an unfair rap. This conversation also comes up in the context of art and other sort of creative uses of artificial intelligence. At least in my view, AI is a tool. It's a digital tool, just like a software development program, a word processing application, a CAD drawing program. These are all tools that people use to create. Yeah, it's faster and it's easier than doing a mechanical drawing by hand or using a typewriter or developing software from binary. But that doesn't mean that these inventions and these ideas don't have value, right? And so, in my opinion, if you just created a chocolate chip cookie recipe using AI and it satisfies all the requirements of a trade secret, it's not generally publicly known, it has independent economic value, and you're going to take reasonable measures to keep it secret, that's a trade secret. But, and this gets back to Elizabeth's question, what is the value, right? And there's no easy answer to that question. There are complex uses of AI models. And we're using the chocolate chip cookie recipe because it's simplistic, but you can go through a series or a cadence of questions to help develop an idea or a concept using AI. And that's still going to create a moat against your competitors. They're not going to be able to repeat that series of questions. And taking it a step further, ChatGPT has an enterprise membership. My law firm has it and we use it. And the advantage of that is that ChatGPT instance is ours. Everything in there belongs to us. We're not training ChatGPT for others to use. It's all kept within our universe. And so that's now a proprietary tool that only we are using and is providing value to us and allowing us to come up with ideas. And so, again, I get back to the digital tool concept. You can use AI to create trade secrets, and as long as the information meets those requirements, you're good to go.
I just want to dig in on one of those specific things, right? So let's say you created it with AI and it's maybe not publicly known because the way that you created it and the way that you asked the questions were detailed enough that you got something there. But then how do you take reasonable measures to keep something secret in this world where things are so much more accessible with AI?
So there's a few things here I think that warrant discussion. The first is, like I just mentioned, the notion of a sandboxed or air gapped instance of an LLM or a chat GPT agent, right? You're now getting information and training a specific instance, a proprietary instance of this tool. So now, yes, you just use a publicly available model to come up with your idea, but that model and the questions and the information that it learned to arrive at that idea are specific to your company. The other piece of this that I think warrants discussion is it's not really a change to reasonable measures. The things that a company needs to do to protect its trade secret intellectual property are the same as they were before AI has exploded, right? It's making sure that all your information is on a need to know basis, least privilege access, meaning that only the people that need access to your trade secrets have access, physical limitations to getting into your building, monitoring your systems for irregular activity, good cybersecurity practices. All of that stuff is still really important. I think what AI has done, though, is it's ratcheted up the stakes. Because before, let's say one of your trade secrets goes out the door for whatever reason. Worst case scenario was someone published it and put it on the internet. That was really bad. But what you would do is you would remediate. You would go to whoever the hosting the website. You would try and do everything in your power to pull down that information. And there were things that you could do. Now, with AI, it's a lot more complicated, right? Because if your trade secret gets out into the public domain and then it gets sucked up by a large language model, however it gets there, it gets sucked up by a large language model. Now, Everyone who has access to that model has access to your information instantly. And the remediation option that I mentioned is not available because the technology right now does not allow you to unteach something to a large language model. I heard a Microsoft engineer describe it as trying to separate the ingredients of a cake after the cake has already been baked. And I think that's a really apt analogy. Once your information is part of the whole, you can't get it back out. And so that brings me back to my point. It is now more important to use reasonable measures because the risk of AI is significant.
So, what is reasonable in a world where your data might only be out on the internet for, a day before it gets baked into, the cake that is the new AI model? You might not even know yet. It seems like a hard standard to meet.
Just like a lot of our legal guidelines, the word reasonable is pretty ambiguous. And like a lawyer, I'm going to say it depends. But I think that, like I said earlier, the things that we have to do as responsible in-house IP people are the same. And yeah, there is a risk that your information still gets out and it gets into a large language model and it's too late before you can do something. But if you've set up the protocols and you've set up the things that protect your information, you've set up intake processes for people coming from outside your company, you've set up exit interviews, you make sure that people aren't walking off with their work computers, you do all these sorts of things to prevent trade secret leakage. Those are reasonable measures. What happens after a bad actor has evaded those measures, you're right, you can't control it. You can do the best that you can. And hopefully that's enough. But I will tell you that in my experience, companies can do more, right? And I think that one of the problems is the perspective that we use to look at trade secrets. Either we're going to be prophylactic about it and we're going to set measures up ahead of time to prevent trade secret leakage, or we're going to worry about it after the fact and figure out, did we use reasonable measures? Did we have the processes in place to make sure that this information doesn't get out? And I think that's a decision that the company needs to make for itself. And I think it's going to depend on the value that you attribute to this information. A lot of times I get questions about, well, should I keep a list? How do I know what's my trade secret? What do I do with the information? And I think that if these companies look in the mirror and think about it meaningfully, it's not that difficult to identify the stuff that really matters. You know what your important IP is. You know what the trade secrets are. If they got out the door, it would be devastating. That's not to say you don't have other things on the fringe that also are your trade secrets. But just because you have a lot of stuff that might be worthy of trade secret protection, that doesn't mean you shouldn't do your best to protect that core information. And I think that's really what the guiding principle should be, is you think about it in tiers. You have the really important stuff and you keep it under a lock and key if you can. And then you don't have to worry about a large language model sucking it up because it's not going to get out the door.
So you touched on the impact if your ingredient ends up in the cake. Is this setting us up for an almost an arms race on the other side of it, that not only do you need to have good procedures to keep things locked up at your company, but also do you need procedures to scour the internet for anything that accidentally got loose? I mean, do you need to have your own AI search function to look for things with your company name on it that have appeared?
That's a fair question. In my experience, and based on my review of kind of the case law in this area, no court has ruled that you need to scour the internet at all times to look for your trade secrets. That being said, if you have a situation where, say, an employee doesn't return their work laptop, right? And you know they didn't return it, and you don't go after them, or maybe you try, but you don't try really hard. And then that stuff ends up in a large language model. That could be a problem, right? That's a situation where you knew there was an issue. You should have taken action to remediate it, and you didn't, or you didn't try hard enough, right? And again, this is all relative and it's going to depend on the facts, and there's no one answer. But that's the piece that we haven't really touched on yet, right? Is how did this information end up in the large language model, right? Is it a bad actor? Because if it's a bad actor that took it out and uploaded it and evaded all of your really, really good reasonable measures, then you could still take action against that person because it's not publicly known through proper means. So if it got out through improper means, then it's still your protectable trade secret, at least from the perspective of the law. You can't unring the bell, and that's certainly an issue, but at least you have recourse. The other side of that, though, is if you don't have reasonable measures, or you're not good about your exit interviews and getting your devices back and what have you, then maybe it's not a protectable trade secret anymore because you didn't do the best that you could, or you didn't implement reasonable measures.
Okay, asking for a friend. What if there were issues with terminated employees during maybe a global pandemic when it was hard to, get somewhere to potentially get a physical item back? Have there been case law discussions on that topic? I just think it'd be interesting to know.
So I have some experience with this. I have seen cases where employees have walked off with devices, and courts generally have a pragmatic perspective on this. Reasonable really does mean reasonable efforts. And if there are some extenuating circumstances, pandemic seems pretty extenuating to me, I think that that's something that would ultimately come into the calculus of deciding whether a company did the best that they could. But again, I think that really the point here is not that you need some earth-shattering system to protect your trade secrets. I think it's more about thinking, if you're going to have a trade secret program at your company, you think about it meaningfully and you take steps to implement it. And then at that point, you use your reasonable efforts. The law is set up to give you recourse if someone evades those sorts of efforts. And by and large, the courts are there to protect your intellectual property. That's why the federal government enacted the Defense Trade Secret Act. That's why, is because they recognize that there is this other area of intellectual property beyond patents, trademarks, and copyright that needs to be protected.
I just want to circle back again on, I think this was in the competitive advantage value section when you were talking about Coca-Cola and their vault in Atlanta. And I've been to that museum, by the way, it's amazing. So, but you were saying like maybe there's a 2% difference in the value that Coca-Cola is bringing, like with their marketing, right? By saying that this is secret and it's in this really special place, and that's what makes it special. I was just wondering if you can kind of tease out the difference between that value from a trade secret perspective and maybe the value that Coca-Cola has from its trademark there. Because it seems to me that that's a little fuzzy for me.
Yeah. So I think part of what's complicated with Coca-Cola is you're dealing with a lot of subjective and emotional factors. Coca-Cola is one of those brands, and Coca-Cola Classic is one of those products that draws out certain emotions for a lot of people for whatever reason. Some people, they love the way it tastes. They've drank Coca-Cola when they were growing up. It's always at those favorite sporting events and what have you. And so on the trade secret part of that, I think, comes out in the taste, right? That's being able to say, this is a Coke. This is a Coke. What you have is not a Coke. It might be close, but it's not Coke. You can't call it Coke. You can't pretend like you use the same formula because you didn't. The trademark is part of that, right? I mean, you get a can of Coke, it's that red color, you see the Coke logo or the Coke bottle, which is also protected intellectual property, the shape of the bottle. All of that comes into play when you're going to have this visceral reaction to a product. Ultimately, whether an AI approximation impacts the value of your trade secret depends on the type of information that we're talking about and the specific independent economic value that your company attributes to that trade secret. If someone can approximate your trade secret through AI, and that approximation is a suitable substitute for whatever product you produce that embodies your trade secret, then yeah, I think that you will have diminished value. But like with Coke, if the AI approximation is not a sufficient substitute or doesn't get the job done in the same way, then it's not going to impact the value all that much.
Well, Steve, thank you for helping us dive into the effects of that we should be looking for as AI continues to expand in use across industries, not just the semiconductor industry, and putting a delicious spin on it, since we were able to talk about soda and cake and cookies instead of the usual silicon, gallium nitride, arsenic, boron, and some of the other semiconductor components that are far less tasty and kind of deadly. But thanks for joining us today, and appreciate your thoughts on this.
Thank you so much for having me. This was a lot of fun.
Thanks so much for listening to this episode of the Semi Interesting Podcast. You can find more episodes wherever you get your podcasts, including YouTube.
And if you enjoyed the episode, we always appreciate 5-star reviews. While we talked about legal issues, none of the information shared during this podcast is intended to be legal advice. If you have any questions about information we cover or ideas for a future episode, feel free to contact me or the other attorneys at Hodgson Russ. You can find contact information at www.hodgsonruss.com.